introduction. We are now, I believe, on week 8 of our 13-week Transition Institute series. And we are really excited to let you know that we are going to continue this series when we return to school sites next week. So for those of you who work for LA Unified and are returning to school sites, please do plan to still log in from your school site. We are going to finish out the 13-week series. With that, I'll say I'm Jackie Tolch. I'm the coordinator of transition services, and we are really pleased that we've been able to offer this opportunity for our transition staff as well as others who have joined us. And I will now hand it over to Anne, who has done most of the work in facilitating and putting this together, to give you a brief overview and introduction of today's webinar. Thank you.
All right, thank you, Jackie, and thank you, and hello, everyone. I'm Ann Nygren, and welcome to the 8th seminar within the Transition Institute. So far, we've learned about A through G, due process, job carving, teaching work readiness skills, work-based learning best practices, student-led IEPs, post-secondary options, and today, guardianships and conservatorships. Not sure about you, but I've always felt that our schools and parents look to us for information on these two, and I've never been super confident in my reply. So today I'm hoping to change that mindset in myself and anyone else that can relate. So today we're grateful to have experts to enlighten us with everything that we need to know about guardianships and conservatorships. It is our hope that we will walk away from today with a better understanding so we can point our students and families in the right direction. Here to take on this task are Deborah Young and Aaron Abramowitz. Deborah Young's practice is focused on estate planning, probate, and conservatorships. Deborah works with compassion and patience to help each client with their unique situation. She graduated from UCLA with a Bachelor of Arts degree in sociology and minor in business administration, and then went on to Loyola Law School, where she earned her Juris Doctorate degree. Aaron Abramowitz is a partner with Enright Ochiltree LLP, and at the firm, Mr. Abramowitz has focused on representing regional centers throughout the state of California. He also represents clients in family law matters, and he was formerly an associate at family law-focused firms, Kolodny Law Group and Trope LLP. So before I hand it over, like our other webinars, this will be recorded, and if you have any questions, please use the Q&A feature, and there should be time at the end to get those answered. Timing wise, we should be wrapped up by about 2 o'clock. And also in the last few minutes, we will post the link in the chat to the 5-question survey asking for your feedback. Thank you all for being here. And with that, I will turn it over to Deborah and Aaron.
Hi, everyone. My name is Deborah Young. And as Anne said, I'm an estate planning, probate, and conservatorship attorney. All of these different areas fall within the probate court, so they're all intertwined in one form or another. And I'm pleased to be a part of the panel today to help educate you regarding what a conservatorship is and what process parents of children who have a form of disability need to go through to be appointed limited conservators. Aaron, I'm going to let you introduce yourself and then
all right.
Take over.
Hello all, Aaron Abramowitz. As I said in my intro, I work at a firm that primarily represents regional centers. So my experience regarding guardianships and conservatorships comes from the regional center side of things. So I'll touch on that a little bit more. I know that you're going to have another series with people coming in to speak from the regional center, but I'll need to touch on a little bit of those issues like eligibility and what the regional centers can and cannot do for those that are largely unfamiliar with them. I wasn't mentioned in my bio, but I too graduated from Loyola. And if anybody's curious, I majored in philosophy in undergraduate. So in theory, I'm going to be able to share my screen and put some PowerPoints up for everyone. And it looks like we did it.
Perfect.
So this is just our little contact info. And then Deb, I'll let you take it away.
Okay. So what I'm going to focus on today is conservatorships, and mainly limited conservatorships. I'll tell you what the difference between a limited and a regular conservatorship is. But first, what is a conservatorship? When we're parents, we're automatically considered a guardian of our children. But what happens when our children turn 18? And even though you're still considered a guardian, you really are not, because at the age of 18, an individual is considered to be an adult in the United States. So what we need to do now is, in the event a child still has disability, figure out how we can still make decisions for the children who are considered adults, but they don't have capacity. So that's where a conservatorship comes into play. A conservatorship is very similar to a guardianship. Actually, a lot of other states actually refer to a conservatorship as a guardianship. California calls it a conservatorship. And a conservatorship is a court process where someone can be appointed in charge of somebody else to make financial or medical decisions for them. The person, usually the parent, who becomes the conservator, files the petition for conservatorship, becomes the conservator, and the adult child will now be the conservatee. Now, a conservatorship can be filed for anyone over the age of 18, whether it's someone who suffers from dementia, has had a stroke, heart attack, a terrible accident. As long as they're not able to make medical or financial decisions, they don't have the capacity, then they need a conservatorship. What we also now need to consider is what happens if someone is developmentally disabled. That is, before the age of 18, they have been deemed to have some form of developmental disability. Autism is a form of developmental disability, but there are a lot of varieties of them. And what this is called is a limited conservatorship. The reason it's called limited conservatorship is because the person in charge, the parent who files this petition to be the conservator, only has limited powers. The court's position is that you don't want to take away all of an individual's rights. So the court will actually look at every case by case and make sure that we don't take away powers from someone who may have the capacity to make those certain decisions. That's why it's called a limited conservatorship. A limited conservatorship is different than a regular conservatorship, again, in that it only applies to individuals who had some form of developmental disability before turning 18. And again, they're allowed to, they've been designed to allow the limited conservatee to exercise some or all of their individual rights and still be able to manage their financial and physical affairs to the best of their ability, and not have the person who's in charge, sometimes a parent, sometimes not, take full control over them. Okay, thank you. Okay, so oftentimes the question is, how can I get this started? How can I file a petition for conservatorship? First, I want to say that the courts, especially the Los Angeles County Superior Court, does have a self-help division for people who are trying to file a conservatorship on their own. And they've been very helpful to people I know. I've never had to speak with them, so I'm not sure exactly what the process is, but I know they do offer that service. And the first step is to file a petition to become the limited conservator. We have to then make a decision, is it going to be over the person or the estate? Now, oftentimes when someone has a developmental disability, they don't have a lot of assets, and there's not really much financial decisions that need to be made. If they are receiving government benefits, for example, Social Security allows a parent to be a representative payee, where they don't need a conservatorship over the estate. But sometimes maybe they're not on government benefits and you're hoping to explore different options. So then we would ask the court to have a conservatorship over the person and over the estate. And the person is making decisions regarding where they live, their care, and that's pretty much doctor visits, medical decisions, and that's where conservatorship over the person comes in. The first question we want to ask, or I usually ask, is, do we qualify for a fee waiver? Because just the filing fee and the court investigator's fee, it turns out to be over about $1,200. That's not counting any attorney fees or any other fees. That's just the cost of filing the petition and having a court investigator appointed. There are 3 ways to qualify for a fee waiver. One is if the proposed conservatee or their parents are any form of government benefits that are needs-based, whether it's Medi-Cal, food stamps, CalWORKS, SSI, SSP, IHHS, and that will allow automatically we mark a box on the fee waiver request, and that's an automatic fee waiver. Another part is on the fee waiver form, there's a box that talks about different levels of income per family. So if your family of 4 falls within one of those categories, then you can qualify for a fee waiver. The last part is there's a sheet on the second page where it asks you to list all source of income from the family and all expenses of the family. So then you can show the court that once you spend all your money at the end of the month, there isn't much money left to be able to afford the court fees. And that's another way to qualify for a fee waiver. It's not the judge who decides whether you qualify for a fee waiver. This is actually a decision made by the clerk based on the information provided. So the first step is to prepare a petition to be appointed and then submit a fee waiver. Now, it's not just the petition. There are a variety of forms that needs to be filed at the same time we file a petition. I list the forms at the end, but I'll just say there's going to be a form that asks detailed information of the proposed conservator, whether they've ever filed for bankruptcy, whether they've ever been convicted of a felony, if they're owed any money, their social security number. The court really does the research to make sure that whomever is appointed the conservator qualifies to be the conservator. The court will also, there's another document that asks for detailed information of the proposed conservatee so they can do the same research. We need to submit another sheet with information of telephone numbers and email addresses of family members and friends so the court can do their investigation. So we file a petition with the court, check to see if we qualify for a fee waiver or not, and then we wait to get a hearing date. And then we go to the court process too. Okay, so we get a hearing date, we get a hearing time, and we get assigned to a department. Once we get a hearing date, a notice will have to be sent out to all second-degree relatives, parents, grandparents, children, grandchildren, brothers and sisters, or aunts and uncles. I missed that there. And in this case of a limited conservatorship, we also have to give notice to the regional center. And Erin will touch base what if somebody's over the age of 18 and they're developmentally disabled and they're not part of the regional center. So Erin's going to touch base on that later down. But if they are part of the regional center, then we have to submit a letter to the regional center asking them to provide a report. The regional center is very familiar with this. And they're very good at getting it filed in a timely manner. So we get a hearing date, hearing time, and a department. What does the hearing look like? Whenever we have a hearing date coming up, nowadays everything is on Zoom. They strongly urge individuals from not going to court in person. So that's one benefit, and it's become easy. The court, Los Angeles Superior Court, has enacted something called an LA Court Connect, which is a very easy way of signing up and automatically doing it via video or telephone and making an appearance. Prior to the court appearance, other things need to happen. Another thing, in addition to the letter from the regional center, we will need a letter. It's called the capacity declaration from a doctor. It could be a psychiatrist, psychologist, it could be primary care physician, but we need someone whose care the proposed conservatee is under to fill this form out. It's a form, and they need to just basically write down who they are, their qualifications, and mark boxes. And this is what the court looks at to actually see, does this person need a conservatorship? Do they lack capacity to make decisions for themselves? So when I have clients, I take care of the notice, but I always ask them, give them a capacity declaration and ask them to please go to the doctor and have this capacity declaration completed. Oftentimes I have to tell them to please make sure the doctor pays attention and fills out all the boxes, because doctors do this so quickly. They sent it back and a lot of missing information, so then we have to send it back. So that's one thing we have to deal with. And then I send a letter to the regional center asking for a written report that they themselves automatically file with the court. The doctor will give me the capacity declaration, or my clients, and then I file the capacity declaration with the court. Can we go to the next slide, Erin?
Mhm.
Thank you. So what does the court do? So whoever files the petition, their job is to give notice, get a capacity declaration, and inform the regional center. So then what does the court do? As soon as we file this petition, the court does three things. But the first thing they do is they appoint a court investigator to our case. A court investigator, there's a specific department in the court system and in the court for conservatorships, and there are individuals working for them, and they're called court investigators. Their job is just as you say it, they're investigators. It's their job to investigate the matter and assess whether a conservatorship is needed. Sometimes they talk to me, they speak to the parents, they try to speak to the proposed conservatee, or if he or she is able to have a conversation. They contact family members we've provided information of to try to really assess the situation, and they provide a report to the court. At the same time, the court is going to appoint another attorney to represent the proposed conservatee. So as an attorney, I would be representing the parents who are filing to become conservators, but the court is going to appoint another attorney, a neutral attorney, to represent the proposed conservatee, the child. Who pays for this attorney? If the family does not have the resources, or if they're on any form of Medi-Cal, or if the child, which in most cases, we're dealing with children who are developmentally disabled, and unless they've inherited a lot of money from other family members, they don't have the funds to pay for another attorney. But Los Angeles County will pay for them. So this attorney will come in, and nobody has to worry about, other than they're going to come and do an investigation as the court investigator does. And there too will file a report with the court giving the recommendation whether a conservatorship is needed. Oftentimes I will speak, or if a person is not represented by counsel, they will speak with the court appointed attorney. They used to be known as the PVP attorney. You might have heard of it, but now they've changed the name in the last couple of years to a court appointed counsel. Same person, this person comes in and represents the interest of the proposed conservatee. This attorney is a regular attorney like myself. Anybody who has had over 5 years experience working, doing probate and probate conservatorships can petition with the court and ask to be put on this panel. Then the last thing the court does is the judges have attorneys working for them. And these attorneys are called probate attorneys. And what their job is, every time there's a matter coming up before the judge, about a week, hopefully earlier, sometimes later, they review the matters that are before the court to see if they have any questions or concerns, and then they give the judge a recommendation. So they could ask us a question, can you clarify the form of disability? Or they could say, the date of birth, can you reconfirm the date of birth? Just random questions that we can answer in a form of a supplement. And once we form it in a supplement, the probate notes get updated. If the court doesn't have any questions, then the matter can be recommended for approval. And then it's before the judge to make the final decision, but at least the probate attorney has done their homework and review, and the judge is able to do a cursory review of what's before them and not have to go through all the details. Thank you. Okay. So what happens at the actual court hearing? Every time there's a hearing before a judge in a department, there is a calendar number assigned to the matter. We know the calendar number in advance because the probate notes that have been listed either a week, 10 days, a few days before the hearing will have the calendar number on them. It's really easy to gain access to the probate notes. All someone has to do is just go to the Los Angeles County Superior Court website, go to the probate division, find the link for probate notes, or go to the search icon and put in probate notes, and then you're able to look it up by a case number. So again, as I said before, even though the courts are open, the recommendation is to make an appearance virtually, whether it's through video or telephone. And it's easy to do. That's another thing. You can just go on the court's website and do a search for LA Court Connect, and the information comes up. And then At that point, based on the information that we presented, the reports filed, the court appointed counsel report, the court investigators report, the regional center report, the capacity declaration, the judge will use all of that information to either grant our petition or deny our petition. I've never had a limited conservatorship denied, because usually it's just parents who've been caring for their kids with a disability up until they're 18, and they're filing this petition so they can continue providing the same care. There's really, conservatorships usually get denied if there's some form of fraud involved or wrongdoing, and that's usually when an adult child is trying to take advantage of a parent. And I had a case where an alcoholic daughter brought mom to court trying to say that she doesn't have capacity because she wanted access to mom's money. So those are instances where conservatorship can get denied, but in the case of a limited conservatorship, it's very rare for a petition for conservatorship to be denied. And as far as the limited conservatee, the proposed conservatee, the child being present at court, the attorney who's representing their interests has the capacity or has the capability of telling the court that he or she didn't think it was good for them to appear in court, and they can waive the appearance of the proposed conservatee. Thank you, Erin. So then let's say the matter gets granted. What happens next? Then an order has to be prepared, laying down all the, it's actually a court form in addition to a document that lays out all the specific orders. This order has to also be signed by the court appointed counsel. They sign on the bottom before the judge signs it, saying, I agree everything on this document is correct. Then the order gets filed with the court. Once the order gets filed with the court and we get the stamped copy back, at that time, we can submit a document to the court called Letters of Limited Conservatorship. It's 2 pages, and it's called Letters of Limited Conservatorship. This is the actual document that shows that anybody is in charge has the power, or is there proof that they're in charge. And that's it. Once the limited conservatorship has been filed with the court, then the parent can make medical or financial decisions depending on what we've asked for. Okay, after the hearing has been granted and the order has been signed, there's 2 additional things that need to happen. One, we need to complete something called the determination of conservatee's appropriate level of care. This is just a form that we fill out where the conservatee is living, what medication they are taking, how many days a week they get to see the conservator, and what their daily lives look like. We submit this within the court within 60 days from the date of the appointment hearing. In addition, we need to send out a notice of the conservatee's rights. And once we do that, then the conservatorship is done and ready to go. The forms I had mentioned in the beginning, these are the forms that for the initial filing, after the initial filing, and after the court hearing. They're easily accessible. There's a judicial counsel form link in the court's website. If anybody can go to Los Angeles County Superior Court, go to the probate division, click on forms, and then there's an additional link that says judicial counsel forms. And the GC references guardianship and conservatorship. So those are the forms, names, and numbers. Okay, and Erin, you want to take over? So this is the part where the regional center and conservatorships go hand in hand.
So I come in at this from a much different perspective than Ms. Young. While she represents typically proposed conservators and maybe sometimes proposed conservatees as a CAC, I myself represent regional centers in these proceedings. How the regional center gets involved in these proceedings, as she said, is in limited conservatorships primarily, but we do get involved in certain general conservatorships when we're asked to get involved. I'll get to a little bit of that as to what the law is behind that in just a moment. But why is it the regional centers are involved? And because the regional centers are the experts at developmental disabilities. So what is a developmental disability? So before we get to that, say, who is then eligible for regional center services, and why is it the regional centers are there in the first place? And it's for individuals who have a disability that begins before that person's 18th birthday, is expected to continue indefinitely, and must present a substantial disability. Now, I know all of you as special ed teachers are familiar with the eligibility criteria for entering into special ed, whether that's emotional disturbance or intellectual disability or ASD. Now, the qualifications to get those are all defined under the Education Code, and they are slightly different than what is under the Lanterman Act, which is what is here under Section 412 of the Welfare Institutions Code. That section of the Welfare Institutions Code defines developmental disabilities. So why the eligibility matters, and why is it the regional centers are looked to in those situations where individuals have developmental disabilities. It's because the regional centers are familiar with the services that are being provided to individuals that are part of the regional center. So the issue is that the court may grant a limited conservatorship, and regional center services might not be available to that individual. Now, there are 7 different regional centers in Los Angeles County. There are 21 within the state, 7 of them are within the county. This is the North Los Angeles County Regional Center, the Frank D. Lanterman County Regional Center, the South Central Los Angeles County Regional Center, the West Side Regional Center, Harbor Regional Center, San Gabriel Pomona Regional Center, and Eastern Los Angeles Regional Center. They each assist people in different catchment areas, which are based on their zip codes. There are certain areas like Burbank and Pasadena, in certain parts of West Los Angeles and South Los Angeles that have shared zip codes, where individuals will, it may vary from street to street. I know that there are some very gerrymandered looking boundaries between West Side Regional Center, South Central Regional Center, and Lanterman Regional Center, where you can walk one street over and you can go from West Side to Lanterman to South Central and then back to West Side if you just keep walking in the same direction. I don't really have a good explanation for why that is, but so it is. So what does it mean to have a developmental disability? So we touched on that you're familiar with eligibility criteria for special ed. Some of the same language is used, but it's defined differently because it's a different statute. So we have intellectual disability, which is formerly mental retardation. The testing for intellectual disability is typically an IQ test. I know we don't like IQ tests, which is why we followed the DSM-5's definition of intellectual disability, which really focuses on adaptive skills, which is how do the individuals interact with the world. The other included developmental disabilities for regional center services are cerebral palsy, epilepsy, autism spectrum disorder, and what's known as the 5th category. And 5th category is basically, well, they don't quite have the IQ cutoff for intellectual disability, or this person is so learning disabled or has had a traumatic brain injury in the developmental period, so before the age of 18, that they interact with the world much as if somebody that was born with pure intellectual disability, so they in turn are eligible for regional center services. In addition to having one of these qualifying diagnoses, the diagnoses must constitute what is known as a substantial disability. So while I have the language here from the statute, really what this means is that it's really got to be a strong impediment to the individual. I'm sure we're all familiar with the different levels of different severity of individuals with autism spectrum disorder. That's why it's a spectrum now. But we're familiar with people that are have really strong adaptive skills and people that would have really weak adaptive skills. So there are many individuals that may have a diagnosis of autism spectrum disorder that qualify for special ed services under a diagnosis or an eligibility of autism spectrum disorder, but do not qualify for regional center services because that autism spectrum disorder is not considered substantially disabled. So there are certain things that are specifically excluded from developmental as a developmental disability. These are things that are solely psychiatric disorders, solely learning disabilities, and handicapping conditions that are solely physical in nature. So we're familiar with a lot of, I'm sure you're all more familiar with learning disabilities, but just very quickly so that you can counsel your students and their families. What is a psychiatric disorder? These are just some examples. Personality disorder, it could be psychosis. There's a lot of overlap between individuals that are actively psychotic and actively hearing psychosis, that there's a lot of overlap in terms of diagnostic criteria with autism spectrum disorder, in terms of people being both distant and not responding to stimuli in a neurotypical way. Learning disabilities, you're all familiar with this, I think probably more than most. There are situations in which somebody can have such a strong learning disability that they can qualify under this 5th category. But typically in those situations, there's something else going on. So it's not solely a learning disability. Physical conditions include certain congenital anomalies, conditions acquired through disease, accident or faulty development. Even though, again, where these things come in is where these individuals can receive regional center services is through that 5th category, where their treatment would be similar to intellectual disability. The example that I gave before with an individual with a traumatic brain injury that requires treatment similar to somebody with intellectual disability. So now that I've talked your ear off about regional center eligibility, why do we care about regional centers and conservatorships? And it's because regional centers provide reports for conservatorships. And it's not just for limited, it's for limited and general. So probate code section 1827.5, I should have like a big banner that flashes with this, with just a bunch of laws about to pop up. I should really have that for non-attorneys that I talk to. But in looking at the statute, 1827.5A requires that the regional center provide a recommendation to the court as to whether or not an individual both qualifies for a limited conservatorship and whether the individual that is applying to become the conservator should be so appointed. And then in 1827.5B, the regional center, it's in a general conservatorship. So this isn't just in the limited space. This is where somebody other than somebody with a developmental disability would otherwise need a conservatorship. The regional center may be contacted. They don't have to be, but they may. So what's in the report? Description of the services, the nature and degree of the disability, and what it is that the regional center is currently providing to that individual. And why that's important is that one of the things that the court wants to look to is the court wants to be able to provide safety and security for proposed conservatees in the least restrictive way possible. It's one of the things that is actually dictated in the statute that if there is a less restrictive option other than a limited conservatorship, they have to go through that. So if through a combination of regional center services and other governmental services, this person can get along, then a conservatorship is not necessarily warranted. That being said, typically, if there's a petition for a limited conservatorship, that conservatorship is granted. Now, there is some weird space between the limited conservatorships and regional center eligibility. So a probate court actually has the ability to determine that somebody is developmentally disabled for purposes of a limited conservatorship without them being a regional center consumer. And just because a probate court makes that decision does not necessarily mean that a regional center will accept them for eligibility. This is a very, 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 very rare circumstance that this happens. However, it is legally possible. And so what is it the regional centers want to do? The regional centers want to provide people with developmental disabilities the most fulfilling and productive lives possible with the most self-sufficiency that they can possibly learn. So one of the issues that comes up frequently with regional centers and with limited conservatorships are parents. And the reason that these come up is what parents look to are, what can I do? And I know that's something that we're talking about here. Is there a possibility of either a power of attorney or an advance directive? This is for people that are over 18, maybe. So what those power of attorneys and advance directives are, it's basically a contract by which a individual over the age of 18 can sign away certain of their rights to other people. The issue with that is you have to have the capacity to enter into one of those contracts. So those power of attorneys can provide certain medical records, but by and large, it doesn't quite get you the same level of power and control over somebody's life as a conservatorship. One of the additional powers that is available in a limited conservatorship is to control the social and sexual contacts of a consumer. I should take a step back really quickly and just say consumer is the language that is used in the Lanterman Act to mean an individual that receives regional center services. I don't like the language. I know a lot of people that don't like the language, but if you'll see this in here, and if I try and say client as much as I can, but the term consumer still slips in there because that's what it does say in the statute. In order to control the social and sexual contacts of a consumer, most regional centers have different services, either to parents or to the clients themselves for social skills and other learning situations that are available to them. There's also the issue of what we do with both mental health and behavioral issues. So mental health falls within another space because people with mental health issues aren't necessarily appropriate for these types of conservatorships. There's a whole other realm of conservatorships that are known as LPS conservatorships. LPS is short for Lanterman Petrus Short. It's the name of the act that establishes them. It allows for you to conserve an individual who is gravely handicapped due to a mental disorder. That is not something that a parent can initiate. So an LPS conservatorship has to be initiated by a clinician. So that means we're all familiar, I think we're all likely familiar with the phrase 5150, if somebody is placed on a psychiatric hold. So there's a 5150, which is a psychiatric hold for a few days. If the treating clinician who is responsible for that person's care in the 5150 doesn't believe that this person can be safely released from the psych ward, then they can be held under a 5250, which can last up to 2 weeks in that same secure psych facility. If during that period of time that the treating physician does not believe that a person can be made safe, then they can make a referral for this LPS conservator. So the LPS conservatorship allows you even more powers that are separate and apart from what we're talking about here in the limited conservatorships, including things like involuntary psychiatric medication. That's a much different talk. That's not something that the regional centers are necessarily involved in, or just something that I happen to be familiar with in all of this. So one of the things that comes up with the limited conservatorships and why people might want to pursue them is regional center services are by their nature voluntary. So no one can force an adult or anyone to receive regional center services against their will. One of the things that a conservatorship does is it stops a regional center client from stopping services. So this happens very frequently with people that have aggressive behaviors or want to not follow the rules of a residential facility in which they are living. So other things that you may want to take a look at, again, these are kind of going beyond what we have here, is what happens financially. So the concerns, of course, are overspending, debt, and vulnerability to fiduciary abuse, meaning what happens if you send the money to a money manager and they just take it. So there are other recommendations that the regional center will sometimes make other than a limited conservatorship, which include establishing a special needs trust, the power of attorney that we've already discussed, making a third party representative payee. So this being a situation in which somebody is receiving governmental benefits. So Social Security, for example. A third party payee can be made the representative payee for those benefits so that the individual that is receiving them that is developmentally disabled is not responsible for their own funds. There's another thing that is money management via regional center vendor. There's a series of regional center vendors that are called fiscal, or fiscal management services. And they basically act as a business manager for clients' funds, so that it doesn't go directly to the client that we're seeking to protect. Finally, other things that are available to regional center services through the regional center are different living options. They can continue to live in the family home. In the family home, there's certain types of supports that the regional center can do, even if somebody is conserved. There are other things such as residential facilities that will have different levels of care depending upon individuals' different needs. There's also supported living services and independent living services. Supporting living services are if you're living in your own apartment or out in a home somewhere else, that the supported living services will support them up to 24 hours a day. And independent living skills are a way of providing the skills that an individual would need in order to live independently through SLS or through something else. Finally, just a couple of services that are available to regional center consumers and to the public at large for both these limited conservatorships and beyond. Regional centers all have educational advocates. Some of them actually contract with outside attorneys. And whether that's advocating at the school district or it's advocating at a higher education facility, they can all assist with that. That SEDEC is a wonderful resource that can assist individuals that are low income with filing these petitions. And that's what we got by way of slides. So there were a couple of questions that popped up in the chat. And if you have any other questions, bring them on. There's a question that says, I have a student who's moving to Texas next year. Do other states have their own version of a regional center? The answer is a crappy attorney answer, which is it depends. So some states have different versions of regional centers. I don't believe that Texas does. So if the student is moving to Texas, then they will have to find services in Texas. It won't be the regional center, but there are other state and federally backed services that may be available.
Wonderful. I thought that there'd be all kinds of questions here.
So did I. We gave a bunch of time.
I know, and all kinds of things to ask. I just know for me when yeah, in an IEP, I remember I've heard different people say, oh no, you shouldn't get the conservatorship for students. It's really, really expensive. So if we hear somebody say that, what would you say would be a good reply?
So it depends. A lot of attorneys charge like around 10,000. I charge 4,000 to do a limited conservatorship. But there are also resources through the court self-help department. Bedside is a really good organization that Erin mentioned, that they provide a lot of support and help families complete these forms. So if somebody really, if they can't afford it and they want to do it themselves, there are resources out there.
Thank you. And can a limited conservatorship ever be reversed?
Yes. Yes.
Okay. I was just thinking like maybe if there is a, well, if it's under review after you apply for it, then if there was fraud found or things like that, they can, or it can be switched over to somebody else, I'm assuming.
Well, remember we have a court investigator. The investigator will do a report, will do an investigation every year and then every 2 years. So they're going to be doing an investigation and providing a report to the court. If they pick up on anything that's unusual, they will bring it to the court's attention and the court will immediately set a hearing date to address it.
Looks like some feedback. Somebody said this was so helpful. Would you recommend a parent begin the process when their child is 17 and a half so they have full or limited conservatorship by their 18th birthday?
Okay, so there's two things to say about this. One is a lot of parents think that if they don't have the limited conservatorship right when their child turns 18, that they're going to be in this dire situation that they can't make decisions. Some people who have developmentally disabled kids go until they're passing without getting a conservatorship for their kids, and as parents are able to make decision and nobody questions it. I had a situation where we actually filed a petition for conservatorship and a doctor has told them, once he turns 18, we're not going to talk to you anymore. I myself, I have a developmentally disabled uncle, and he's 50. We didn't need to file it. My grandmother passed away last month, and now we're filing a petition for limited conservatorship. So it's like on a case-by-case basis, and it depends what happens. But if for their peace of mind, if a family wants the limited conservatorship in place, the recommendation would be 4 to 5 months before their birthday to file the petition. Because of COVID, unfortunately, the hearing dates are a lot further away than they used to be. It used to be 2.5 months, and now we're looking at 4 to 5 months.
Then we had another question that just came in. Limited conservatorships are only available to individuals that are developmentally disabled. And the definition of developmental disability for these purposes means that they have to be exhibiting the symptoms of the developmental disability before the age of 18. So it doesn't necessarily need to be diagnosed. There's lots of cases that pop up, less and less, but there are cases that still pop up of older individuals that are then in their 40s that come into a regional center for the first time and could have been diagnosed when they were in their teens, just never were for one reason or another.
Someone's asking, single parent is under chemotherapy and applies for conservatorship. Can she include others as conservators?
Yes. So in a situation like that, they could at the same time ask for someone to be co-conservators with them. You could never put a backup in case you're not able to. We can't appoint successors, but we can appoint co-conservators. In that case, when one is not able or willing, then the other one can step in as conservator. I have, she's also an attorney, a friend who we did a conservatorship for her son who's autistic. every 2 years she adds another person. So now we have 4 co-conservators because she's always paranoid that something's going to happen to her or all the other listed individuals. And the court, at first when we were going for the 4th, I told her, I'm not sure if the court will be okay with this, but they granted it. So you can have co-conservators.
Someone is asking, is it true that conservatorship should not include love life? I'm assuming.
So again, you're going to get a crummy attorney answer, which is it depends. So there are certain individuals that can make decisions for themselves, but the power over relationships and sexual relationships is really important with individuals that really lack the capacity to consent to sexual activity. And this helps stop situations in which people can be taken advantage of. Next one, how long does it take for to become a regional center client consumer? About 120 days is what the statutory time is. It can take less than that depending on the number of records and how sort of clear cut it is. There are certain individuals where just they will come in with such a bulk of records that it's very clear that somebody's going to end up being eligible. COVID, of course, has lengthened that a bit because it's much harder to do face-to-face meetings, and especially testing for autism spectrum disorder. It's much harder to do via screen because certain things that you look to in certain autism screenings, you can't do if you're not face-to-face with somebody. So it's taking a little bit longer to get those back on closer cases, but the regional centers are pretty good about getting it within that 120-day requirement. Next one is, would a student with psychosis or schizophrenia be conserved by a parent or court-appointed conservator? Another crappy attorney answer, it depends. It would depend on what it is that you're looking for. If you're looking to make sure that somebody will take their psychiatric meds, then it's gotta be through an LPS conservator, because that's the only way that a court can make an involuntary medication order.
I'll take this one. When do you recommend conservatorship and when do you recommend a power of attorney? It depends on the level of capacity that the person has. If they're able to understand what it is that they're signing, if they're able to understand that they're giving certain powers away, then they can sign a power of attorney. I mean, again, you can print a power of attorney online. If an attorney is going to prepare it, an attorney has to feel confident that this person has capacity and understands what they're signing. In addition, it's going to get notarized. So a notary will have to be confident and believe that this person who's signing is aware and has the capacity to understand what they're signing. That being said, if this person who does have developmental disability does have the capacity to be able to make such a decision, that's when you do a power of attorney. You do a conservatorship when someone doesn't have the capacity to understand or be able to sign a power of attorney. So the first least restrictive alternative is always the power of attorney.
I think this one's for me. For LAUSD, for students on the alternate curriculum, does that automatically make them eligible for regional center services? No. Regional center eligibility is dictated by the Lanterman Act, and alternate curriculum and other LAUSD special ed requirements are dictated by the education code, and they are very similar, but they are different. It is easier. I mean, it is less restrictive getting the special ed requirements than the regional center eligibility. However, frequently it will happen that you'll be eligible for both, but it does not automatically. You want to take the next one?
Yeah, I'll take it. So if a client turns 18 and the process has started, but there's a decision to be made right away, who would make the decision at that moment? A decision cannot be made at that moment. What we would have to do is file an ex parte petition, which an ex parte petition means an emergency petition. basically go to court on an emergency basis and ask for a temporary conservatorship until we get to our main hearing date. A petition for temporary will give someone temporary powers, and it will give specific temporary powers until we get to the main hearing. So we would have to then file an ex parte petition for temporary letters. But it's possible. Is an advocate, parent, family member without a law degree able to receive training to complete the paperwork? Absolutely. There's a lot of resources online just by simply Googling. Is one of them. You can just Google how to complete conservatorship forms. Betsedic is another organization, the self-help department in LA County. There are a lot of resources out there for someone who has the time and the energy and wants to learn to do it, they can. Another thing to say, the probate courts are lenient. First, and I should have said this in the very beginning. When we're saying probate court, the civil court, like you have different areas of the court system. Civil talks about if it's like a lawsuit, personal injury lawsuit, business lawsuit. Then we have family court. That's when people are getting divorced. And then we have the probate court, and that's when it deals with whether somebody has capacity and when somebody passes away. So conservatorships fall under the realm of the probate court. So that's why we've been saying probate court all this time. But the probate court is very lenient. If you file a petition and you did something wrong, they will tell you what you did wrong and give you an opportunity to fix it. It's never the end of the world. And I want to say, if I'm happy to answer any questions for parents, you guys as teachers, if anybody, my email is going to be available. I'm happy to help and answer any questions and provide guidance to anybody that needs it. Okay. Next question. When a person has a conservatorship, how do they show to a third party, doctor or tattoo artist, that they have the rights over the conservatee? So if you remember, once the order has been signed by the judge, I said we can submit a document to the court, and it's called the letters of conservatorship. Once that document gets stamped by the court, that's the ticket. That's the proof. That's what you can show anyone to show that you're the conservator and are able to make medical and or financial decisions. So the letters of conservatorship.
So a question I've heard come up is like, let's say you don't do a conservatorship and the individual at 19 goes and buys a brand new car, somehow signs some loan agreement, and doesn't have the conservatorship. So no protection for that person in that situation, right?
Right.
But let's say that mom did have conservatorship, but 19-year-old did the same thing. Then what does that look like? Mom can come back and show that she's conservator and cancel?
I would hope so. I would think mom can go and have proof. I have proof that he doesn't have capacity, and you guys should have known he doesn't have capacity. I don't know exactly what it's going to look like. I haven't seen it happen, but that would be my initial reaction. Some schools have asked the student to sign an education code while the parent is working on the conservatorship process. How long can the education code be in effect? That I don't know.
I'm not sure. I'm not sure what an education code. Just the.
Yeah. Sorry, we don't know what an education code is. Danny, do you have a Spanish speaker on staff in case parents have questions? My husband, so he's my translator. So yes, if any Spanish speaking families have questions, I'll be more than happy to help them.
Okay, wonderful. And I placed in the chat box the copy of today's presentation. So if you want to click on that link now to make sure to capture it if you were interested in having a copy of the slides today. Also in the chat is the survey. If you as attendees could click on that and answer the few questions, that's really helpful to us. It doesn't look like there's any more questions, but I think this was super helpful, and I think it's something that all of us will benefit from knowing a little bit more about, and you will probably be hearing from some of us with some follow-up questions and things that might come up in the future. But we really thank you guys for taking the time out of your busy schedules to help enlighten us with all of this information. And thank you all for attending. And if there are no other questions, that will be it for today's webinar. Stay tuned for next week for our seminar. It's on the transition tools and resources. So we will see you here back next week. Thank you, everybody.
Thank you, everyone. And
Thank you all for having us.
Thank you.
Thank you.
Thank you. Okay, well, I'm going to go ahead and hit end. It is going to end the meeting. And again, thank you.